Welcome to our deep dive on U.S. birthright citizenship. In this video, we will unpack the constitutional basis of the right of the soil, clarify common misconceptions, examine political debates, and explain why citizenship acquired at birth is among the most secure legal statuses in the United States. Let's begin by framing the core constitutional principle before moving into the legal precedents and practical implications. Here is our roadmap. First, we will cover the constitutional foundation. Next, we will define Jus Soli and contrast myths with facts. Then, we will analyze political debates and discuss attempts to change birthright citizenship. After that, we will show who is covered and how to confirm citizenship. Finally, we will test your knowledge with short quizzes, summarize key points, and conclude with an important disclaimer. Jus Soli is the legal principle that a person's birthplace confers nationality. In the United States, the 14th Amendment embodies this idea. If a child is born within the United States and is subject to U.S. jurisdiction, the child is a citizen at birth. The primary, well-known exception involves the children of foreign diplomats, who are not considered subject to U.S. jurisdiction for these purposes. Now that the concept is defined, let's connect it directly to the Constitution. The 14th Amendment clearly states that all persons born in the United States and subject to its jurisdiction are citizens. The Supreme Court in United States v. Wong Kim Ark in 1898 affirmed that the amendment's text is to be understood broadly. Under this framework, the immigration or visa status of the parents, whether temporary, out of status, or undocumented, does not prevent a child born on U.S. soil from being a citizen, provided the child is subject to U.S. jurisdiction. This is not a discretionary agency policy. It is a constitutional guarantee. Next, let's clear up common myths that continue to circulate. A recurring myth is that a president can end birthright citizenship via executive order. That is incorrect, because constitutional rights cannot be undone by unilateral executive action. Another myth suggests that children born to tourists or undocumented parents are not citizens at birth. That is also incorrect. The 14th Amendment covers those born on U.S. soil and subject to U.S. jurisdiction. Finally, the belief that Congress can easily change this principle ignores that it is constitutionally guaranteed and reinforced by Supreme Court precedent. With those misconceptions addressed, let's discuss why the political debate persists. Debate persists largely because some proponents argue that the 14th Amendment was never intended to cover the children of visitors or temporary residents. However, the text is straightforward and, as interpreted by the Supreme Court, has a broad scope. Most legal scholars agree that the amendment covers nearly all individuals born within U.S. borders, with narrow exceptions. Therefore, any attempt to change birthright citizenship through executive action or ordinary legislation would be challenged immediately in federal court. To see how such attempts typically unfold, we can visualize the process next. This timeline traces key moments: the 1868 ratification of the 14th Amendment establishing birthright citizenship, the 1898 Supreme Court decision in United States v. Wong Kim Ark affirming the principle, the 1924 Indian Citizenship Act clarifying citizenship for Native Americans, and the 1982 Plyler v. Doe decision recognizing important constitutional protections for undocumented children in education. In the 2010s and 2020s, political proposals to alter birthright citizenship reappeared, but the prevailing legal view continues to recognize the constitutional foundation. This historical context shows how consistently the doctrine has been articulated and defended over time. An executive order cannot override a constitutional provision. If such an order were issued attempting to curtail birthright citizenship, it would prompt immediate litigation. Federal courts would likely issue preliminary injunctions to halt the order's enforcement, followed by appellate review and potential Supreme Court consideration. Given the 14th Amendment's text and long-standing precedent, courts would almost certainly strike down an order that conflicts with the Constitution. This is why citizenship conferred at birth is considered extraordinarily secure. Now let's specify who is and isn't covered. This table clarifies coverage. Those born in the 50 states and the District of Columbia are citizens at birth under the 14th Amendment, assuming they are subject to U.S. jurisdiction. Individuals born in Puerto Rico, Guam, the U.S. Virgin Islands, and the Northern Mariana Islands are also citizens at birth by federal statute. Individuals born in American Samoa and Swains Island are generally U.S. nationals at birth under statute, not citizens.
unless a parent is a U.S. citizen under qualifying circumstances, or citizenship is acquired later. Children of foreign diplomats born in the U.S. are not considered subject to U.S. jurisdiction and are not citizens at birth. Children born on U.S. soil to undocumented persons or temporary visitors are citizens at birth, as they are subject to U.S. jurisdiction. With coverage outlined, let's also map the concept of Jus Soli for clarity. This mind map ties together the key components: the 14th Amendment with its jurisdiction clause, the scope of who is covered when born on U.S. soil, the narrow exceptions like children of foreign diplomats, and the territorial nuances such as American Samoa. It highlights the core precedent of Wong Kim Ark, identifies practical proof such as a birth certificate or U.S. passport, and underscores that any change would need to survive constitutional scrutiny in the courts or involve constitutional amendment. Now, let's walk through how someone typically confirms birthright citizenship. To confirm citizenship acquired at birth, obtain a certified copy of your birth certificate from the state or jurisdiction of birth. Ensure your birthplace is within the United States or a qualifying territory, and, where relevant, verify that your parents were not foreign diplomats at the time of your birth. For proof of citizenship for travel and other purposes, apply for a U.S. passport using the appropriate State Department form, such as DS-11, for a first-time applicant. Maintain certified copies of vital records and your passport securely for future needs. With documentation covered, let's test your understanding with a brief quiz. Quiz time. The question asks, which group is generally not a U.S. citizen at birth when born on U.S. soil? The options are A. Children of foreign diplomats, B. Children of undocumented parents, C. Children of tourists, and D. Children of temporary workers. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is A. Children of foreign diplomats. They are generally not considered subject to U.S. jurisdiction for 14th Amendment purposes, and therefore do not acquire citizenship at birth in the United States. The other categories are covered when the birth occurs on U.S. soil. Second quiz. The question is whether a president can end birthright citizenship using an executive order. The options are A. Yes, B. No, C. Only for children of undocumented parents, and D. Only if Congress agrees by simple majority. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. No. An executive order cannot negate a constitutional provision. Attempts to do so would face immediate litigation and are likely to be blocked by the courts based on the 14th Amendment and relevant precedent. Let's compare two concepts. Government revocation does not apply to valid birthright citizenship, which is secured by the Constitution. Without a constitutional amendment, attempts to revoke such citizenship would not survive judicial scrutiny. In contrast, voluntary renunciation is an individual's formal decision to give up citizenship, usually conducted at a U.S. consulate or embassy, with significant legal and potential tax consequences. Renunciation is rare and intentionally rigorous. This contrast shows why citizenship at birth remains secure, absent a voluntary, formal renunciation. A valid U.S. passport generally serves as conclusive proof of U.S. citizenship for travel and many official purposes. For first-time passport applications, a certified birth certificate along with acceptable identification is required. Maintain your documents in a secure location and keep them current to avoid complications. Next, we will consolidate the key points you should remember. These are the essential takeaways. The 14th Amendment guarantees birthright citizenship for those born on U.S. soil and subject to the jurisdiction of the United States. Supreme Court precedent firmly supports this understanding. Executive orders and ordinary legislation cannot negate this constitutional right. A primary exception involves children of foreign diplomats. For practical proof, a valid U.S. passport or certified birth certificate is typically sufficient. This content is educational and does not constitute legal advice. Individual circumstances can be complex and may require consultation with a qualified attorney who can evaluate the facts and applicable law for your situation. Laws and interpretations can evolve, and official guidance may change. Always verify with authoritative sources and legal counsel. In summary, the principle of Jus Soli is anchored in the 14th Amendment and has been consistently upheld by the Supreme Court. While political debates continue, constitutional rights are protected by the courts. Citizenship at birth is durable and secure against unilateral attempts to revoke it.
For practical confirmation, rely on official documents such as a birth certificate and U.S. passport.
As we close, we invite your engagement to help share accurate information.
Thank you for watching. If you found this helpful, please like the video, share it with others, and subscribe for more content. Let us know your questions and experiences in the comments so we can continue the conversation.